Welcome to yet another lecture in our series that we normally present at iClass, a virtual YouTube channel. Today our lecture is entitled How to Find a Legal Case in South African Law. Thank you very much for taking your time to watch this video, and thank you very much for supporting me throughout this time that you've been a loyal supporter of this channel. If you are new to the channel, just remember to click that subscribe button and to click the like on the video so that we can upgrade the algorithm that promotes this channel and these videos for the benefit of other people as well. You know that we need to support one another. While I support you by providing these videos, remember to be also mutually supportive by clicking and sharing with your friends and all your other associates. So as I have already said, my name is Dr. Philani L Ndlovu, and my channel is iClass Virtual, and my email account, if you want to raise any issues, raise any concerns, ask any questions, and give feedback on whatever you think might be matters of importance, there is my email address there. It's iclassvirtual@gmail.com. Remember to support, remember to share. That's very, very important for us to promote this channel. As I have already said above, we are looking at how to find a case, a legal case that is, for use in South African courts and in the South African legal system generally. Whether you are a student of law or you are just a lay person in the community interested in the law, or you are a legal practitioner, let me remind you of the importance of reading cases, understanding legal cases. South Africa's system of law is run or based on a common law system whereby the system of precedent is very, very highly valued and highly respected. You know that in terms of the common law, the decision, that is the previous decisions of the courts, are actually relevant in our understanding of current matters before the courts, as well as maybe predicting how a particular case may develop. So it's called a system of precedent, or binding precedent, or stare decisis. I do have another video where I've addressed that issue. Feel free to just check one of those, the particular video that looks at stare decisis, so that you understand the hierarchy of courts in South Africa, as well as how a case decided in one court affects or determines the cases that will be decided later on by other courts. Because you see, as I have already said, the stare decisis principle is central to our understanding of law. Why is that the case? It is because the courts are enjoined to interpret the Constitution, or to interpret legislation, that is acts of parliament, or subsidiary legislation, which could be ordinances and decrees passed maybe by the executive, maybe just to handle matters of an urgent nature. And the courts also apply the common law, they apply African customary law and many other systems of law according to, as they are captured for us in Section 39 of the Constitution. Of course, we know that Section 39 just mentions some of them. It's not a one-stop shop, one could say. But as I have just said, because the courts have to interpret the constitution, the legislation, and apply common law and African customary law. It goes without saying that when we are seized with a matter or a problem, a legal question at a particular time, we always want to look back at how the courts have interpreted the law related to the facts that we'll be facing at that particular time. So it's very, very important for us to then understand how to find a case, how to read a case, how to summarize a case, how to brief a case, because that is always very, very important. You see, understanding cases and knowing how to read and summarize them is very essential for your studies as a student of law, as well as a practicing lawyer, whether an attorney or an advocate. Because remember, daily you will be faced with cases. You have to apply the rules of law. You have to find out how the courts have interpreted them. So summarizing and reading and summarizing a case is part of your daily role and duties as a legal practitioner. So you have got to master that. And the other issue is, again, as an attorney or an advocate, let's say a legal practitioner, you might be representing a particular client, and then the matter goes from the first stage until judgment is delivered. Remember, it is still part of your mandate after the delivery of judgment, whether it's a favorable judgment or it's adverse to the interests of your client. You still have a duty to read and understand that legal case, because you will have to file an appeal in favor of your client, or you may have to defend an appeal if your client has been victorious in that case and the other party to the case, to the dispute that is, decides to launch an appeal. So your client will be looking up to you to read the case, understand it from the beginning up to the end, the judgment, how the court admitted evidence, and how it interpreted every piece of evidence, and how we dealt with the legal questions, and the reasons for the judgment, what we call the ratio decidendi, as well as the findings of the court. You have got to interpret that to your client. So it is very, very important for you to understand that your understanding of the case is not just for the cases or the sake of the examinations. Neither is it just for the sake of maybe finding relevant law to argue in court, but it is also significant in terms of reviewing the case, so that you can properly advise your client whether you should not an appeal, whether you should defend an appeal, and so on and so forth. So you must take note of that. So in reading your case, you'll have to take note of the key elements, as I've already highlighted: your facts, your legal question, your ratio decidendi, as well as the finding of the court. And then again, having to maybe in the preliminary stages of the case, you have to investigate the case. You've got to write a memorandum, that is an office memorandum, pending proper advice to the client. So you must fully understand how a case gets to be structured, so that you can prepare adequately and find the relevant principles of law, find the appropriate interpretations of the principles or the rules, the legal rules that are applicable to your case, and so on and so forth. Now, having given those preliminary issues above, let me then come to the point of saying, how do we look for cases? That is the legal cases. Where do we even look? How do we look? How do we decide what case to look for, and so on? You may look for a case using maybe some case references. For instance, you may already be aware that in dealing with the rights and the status of an unborn, there was a dispute that involved Pinchin and another versus Sanlam Insurance Limited in 1963. It was actually a landmark decision which has continued to be relevant until the present day. That is the issue dealing with the Nasciturus fiction and whether a fetus has any rights, whether any injuries that a fetus suffers before birth can actually give rise to a claim when it is born, and so on and so forth. So if you've got that case reference, you may look then for the case using the reference or the citation. Or if you know the names of the parties who were involved in a particular legal dispute, you may use their names to search. We have got some electronic directories and indices such as LexisNexis, Butterworth, and Tutorstat. But maybe if you are looking for those cases to do with, say, foreign law, that is English law, American law, you could actually also refer to Westlaw, which is another directory of legal cases and legal authorities, alongside LexisNexis, as well as here in South Africa we have Tutorstat. Of course, you can also make use of directories such as Safli, or you can also just go into a search engine like Google and any other search engine that may be able to assist, and then type the references or type the main maybe issues around that kind of a case. And then thirdly, you can use a specific topic to search the indexes, like I have spoken about LexisNexis and Tutorstat and so on. So you just go into those electronic directories, and in those search boxes you type the keywords, then it will pop up and you'll be able to follow it up. But maybe you also need to be just reminded that these Tutorstat and LexisNexis, what do you call them, directories, are accessible through, if you subscribe to them, you then get a password. Some universities, in fact most universities, if not all universities in South Africa, that is the colleges of law, have actually subscribed to Tutorstat and to LexisNexis Butterworth to give you that access, so you can actually look through those and be able to find the cases. They also happen to house the, what do you call this, the statutes, that is acts of parliament, so you can actually follow through on those directories. Now, talking still about these sources of law, as I have already highlighted, LexisNexis or Tutorstat just happen to house what we call South African law reports. It's only that they are now in the electronic format, but otherwise you find they are law reports to do with Southern African law since 1826 to 1946. So you find that these ones are Southern African, which means they include the decisions in Botswana, that was then Bechuanaland, as well as the decisions taken in Southern Rhodesia, that is now currently Zimbabwe, because then you find that the system of law was integrated. There is what are called note hubs. We will say a little more about them later on, but these are case annotations which give you a detailed review of how a case, maybe from the time a particular case was decided, how it has been treated by other courts or subsequent court decisions, whether it is still authoritative or whether it has, been reviewed and certain qualifications have been attached to it and so on and so forth. So it's like you are following up on the application of a particular legal principle or rule, and you are inquiring and tracking how it has been applied from maybe the first time, like we spoke about the pinch-in case of 1963. How has it developed up to the present day? So those are issues to think about. So we are saying these Butterworth's consolidated index and nota up to the South African law reports are very, very significant in that regard. As I have said, Juta also has the same index and with rather similar directories. We've got many other law reports, the South African law reports from 1947 up to the present day. With South African criminal law reports, the constitutional reports of South Africa since 1994. We have other law reports, that is arbitration law, labor law, competition laws, and so on. And as I have already indicated, you can go on to the online sites and check for the cases, the Southern African Legal Information Institute, that's SAFLI, or the Constitutional Court of South Africa website, or the Supreme Court of Appeal website, because these courts have websites wherein they list and they post their decisions so that they can be accessible. We spoke also about the search engine Google and how it comes in handy. So remember to consult those sources. A very important matter, maybe in connection with this, is the citation of the case. For instance, imagine, well, maybe you don't have to imagine. We have a case here, S versus Thabo, 1993, 1 SACR 203T. Now, as you follow up, you find that the parties are S versus Thabo. In this particular case, it's the state versus Thabo. We know it is a criminal case report because it has the state as a participant, and wherever we have the state as a participant, as a bearer of state authority, it can only be a criminal offense that was being dealt with. So it is the state versus Thabo. The case was reported in 1993 in volume 1 of the South African Criminal Law Reports, and it was reported on page 203, and the matter was heard at the Transvaal, the then Transvaal division of the High Court. So this is very, very important. This citation is important because then it gives us the details about the case itself, whether it was a criminal case or it was a civil law case, and so on and so forth. It's very, very important for us to take note of the citation. And in your, whether you are writing an assignment, or you are writing an examination, or it's a journal article, or it is a, like in legal practice, you could be doing a case brief, that is a trial brief, or you could be drawing your legal opinion, or what you call this, when you are advising, we called it a memorandum, a case memorandum, or an office memorandum, where you are inquiring into the merits of the case and trying to get the facts as objectively as possible, so that you can give a sound and accurate legal advice to your client. So when you are writing any of those, whether they are predictive forms of writing, or you are indulging or engaging in persuasive writing, this is the citation that you must always follow, because it's very, very important. It's for consistency, to enable the courts, or the other readers of your writing, to be able to trace and find out exactly where to find the case or the authority that you are referring to. Earlier on, when we were talking about where to find sources, I did hint that there is a need to inquire into whether a case is still authoritative or not. For instance, a case that was decided in 1963, can you still boldly cite it as an authority in 2022? Are you sure that it's still valid? It's still available, as it's still good law? It still represents good law? That's the question that you must always be ready to answer. So you find sometimes cases get confirmed by subsequent decisions, or they get overturned by subsequent court decisions, so that you find maybe the case that was heard, our example there, the Pinchin versus Sanlam, it has since been heard in other cases subsequently. So how has it been dealt with? So has it been discussed? Has it been applied? Has the principles, because you see, it's about the principles, the main principles, or the main legal rules that were being discussed there, the issues, are they still applicable, or they were compared to other principles in another case, or was there a reference to it, maybe obiter dictum, that is as an incidental remark, or was it considered in another case? Has it been distinguished from another case, or has it been qualified? As I have just said, subsequent court decisions do play a role in terms of either qualifying, or overturning, or distinguishing, that is, prescribing or circumscribing the circumstances in which a particular principle is applicable. So it's very, very important for you to take note of all those things. For instance, if a case no longer represents good law, you find that then it's no longer as authoritative, or it's not authoritative at all. Maybe a new case, or a new interpretation of a statute, or a new interpretation of the law, or the common law, or whatever, has actually displaced it. So if it has been displaced by another, you need to keep abreast with those changes and those developments. That's where then comes in the issue of the nota apps. As we spoke about the Butterworth's nota apps. You see, Butterworth's law reports track every case that has been reported, and then they keep a record of all these confirmations, or the overturning, or discussions of it, or its application. They keep a record. So it's like when you go into the electronic directory, that's the Butterworth's or Tutorstat, they will the index will actually show you that the case they will show you whether the case is still authoritative or not. All these other qualifications, references, obita and so on that have subsequently taken place, you'll be given an update so that you can be able to determine whether it's still the case still represents good law or it has fallen out out of use, so it has actually lost its status as a valid and authoritative legal case. So we are saying in short that nota apps or case annotations give clarity to these issues. So if you check the LexisNexis Butterworths, or you check Tutorstat directories for annotations, or Westlaw if it's about a non-South African case, you will then be informed adequately whether the case is still in a good standing or it has been overtaken. So as I said, in summarizing a case, you will have to take note of quite a number of headings also, because summarizing a case is based on a certain structure. But I do have a video where I pay more attention to this. I'll just mention this in public, sorry, in passing. Please ensure that you look out for my other video on this one. But the most important issues in summarizing a case, we have the parties themselves. Who are the parties? We gave an example of S versus Tabo. And then what are the issues? You must find out what the issues are through that reading. Then the facts, including the procedural posture of the case, and then the legal question that is looking at the legal rules that are being applied there. And then you also look at the ration decidendi, or the reasoning of the court and the finding of the court. I'm not going to dwell much on that one. Just make sure that you find the relevant case in my repertoire of videos, so that it can clarify that for you. Once again, thank you very much for being part of this presentation today, whatever time you're going to watch it. I certainly hope that it has blessed you. But before you can click the next video that you're going to watch, remember to subscribe to my channel, hit that notification button, click your likes also, and if you need to get to me for any reason, just drop an email at iclassvirtual@gmail.com. Thank you very much. May God bless you.